Hello, everybody. Thank you very much for joining us for the next panel on our program. This is going to be Navigating the Unknown Law in the New Space Age. We have a fantastic group of panelists here in front of us. I am going to technically moderate, but try to do as little talking as humanly possible, which anyone who's ever been on the Zoom call with me knows is easier said than done. So we're going to start a couple minutes early because there's a lot that folks really wanted to be able to talk about. So with that, I think we should probably just go down the line. Introductions, who you are, how you got here, and your road into space law.
Yeah. Michael Castle-Miller. I'm here starting a new project called the Lunar Development Co-operative. And my background is actually in economic development. So after law school, I worked at the World Bank briefly, and then started working as a consultant in a strange little niche called special economic zones, which are, I like to call, areas with different laws than the rest of the country around them. And so we help develop the legal and policy and regulatory frameworks for special economic zones in about 35 countries. And about 6 years ago, I started talking with several space experts on how we could translate that to creating a framework for supporting lunar economic development. And the LDC is the product of that. And so I left my job at Albright Stonebridge Group, or as a partner there, and am leading the LDC effort now, which we'll be talking about more.
Hi, everyone. I'm Neha Dagley, and I am the founder of a law firm called SpaceMarked Legal Advisory. I want to give you a little bit of background about how I got into space, because I think it's important to get the message out there that space is really for everyone. I grew up in Mumbai, India, and my family moved to the United States when I was about 15 years old. I was very much interested in pursuing something within astrophysics or becoming an astronaut, but things didn't just work out that way. So I did the traditional path to law school. I worked as a litigator for 18 years. And during that time, not only did I do commercial litigation, but I also did bankruptcy litigation, jury trials, federal class action work, everything but space. And about 2 years ago, I made a decision to give up a big law firm job and moved to the Netherlands, and I pursued an LLM in air and space law with a special focus on space. And here I am now, sitting here speaking at the New York Space Forum. And I'm very excited to be here, and I hope that this encourages those who perhaps are on that cusp of not sure whether they want to go into space or whether it's too late or too early. Just my advice to you is to just go for it. So, thank you.
Hi, good afternoon. My name is Marlene Losier. I'm a legal expert in international law, and I specialize in areas beyond national jurisdiction and conflicting jurisdiction. I started off as a very happy anthropology student and moved into government, not wanting to go into law, but eventually did, and worked with dispute settlements in oil and gas and other international issues involving energy, sovereign immunities, and at a large law firm now, Norton Rose, and did some corporate work as well, but was not very satisfied, and then left to do a PhD in public international law on auctions of cultural objects, movable cultural objects, moved into title rights over the cargoes, very valuable cargoes of sunken colonial vessels found in international waters and in conflicting jurisdictions. And that kind of took me to this idea of cultural sites on the moon. And for the last 8 years or so, my practice, which I have in DC, focuses on title and proprietary rights over movable cultural objects that are on land, under the water, or imported, exported from space. Sites, but specifically in terms of space, developing the new space law regime, extending the 5 UN space law treaties, and looking at bilateral agreements that have to do with investments in space, sites, importations, exportations. And so I advise public and private clients on these subjects in many forums like the UN and the International Astronomical Federation, where I'm co-chair or chair the Committee on Liaisons with Developing Nations, and looking at the expansion of the space market into those regions, as well as the Committee on the Cultural Uses of Space. So I spent a lot of time both in Paris at UNESCO and in Vienna at the COPUS. Thank you. Nice to be here.
Yeah, it is really nice to be here. I just wanted to say, talking about space is probably one of our favorite things that we all do. And thank you to Patrick and Empire Space, really, for organizing the event. My name is Glynn Torres-Spelliscy. I am a lawyer and an academic. I teach classes on international law and space law at a number of institutions, including the New School down here in New York. I began my career as an international regulatory attorney at Arnold & Porter, which used to be just right up the street here, so I know this neighborhood quite well. I focused on international regulatory matters, FCPA, that type of investigations. I also had a very extensive pro bono practice where I focused on human rights, sovereignty, self-determination. I spent a lot of time thinking and speaking and writing about issues of self-determination, particularly for non-self-governing territories. As for how I got into space law, it's kind of a funny, silly little story. I remember very clearly I was out walking my dog, listening to a podcast, and Alan Stern, who headed NASA's New Horizons mission, he was on the podcast and he was excitedly saying, I think the 2020s are just going to be the roaring 20s for space. And that immediately kind of set off alarm bells for me, because I think Alan was talking about it as a good way, but I thought to myself, well, wait a minute, we know how the 2020 or the 1920s ended, and spoiler alert, not well. And it took like an entire decade in the 1930s to build out a regulatory structure to fix that. So I started thinking about, one, how do we educate the next generation of people who are coming up, who are going to be the ones that write the space laws and the regulatory laws, and how can we do that sustainably? Because as I sat there thinking about, I firmly believe that the future is space. And in fact, that is the title of my first lecture that I gave in my space law course. The title is "The Future is Up." And I truly believe the future is up. But I am, maybe it's because I'm a lawyer, I am a worrisome individual. And I worry that our regulatory structures, our legal systems aren't prepared for that expansion yet. So, a lot of my work has been focused on how do we get ready? How do we make sure we are ready? So I'm excited to be here and to talk with you guys about that today, and thanks for having me.
Thank you. I think I will agree with Glenn. It is our job as lawyers just to worry generally. So I worry all the time, sometimes about work, sometimes about random stuff. My name is Tony Lin. I'm a partner at Cooley LLP. It's an international law firm, and I apparently am the only person that's still at a large law firm. So I don't know what that says, but I'm kind of happy. And I'm happy because I do a lot of stuff that that brings me joy. But I'll take a step back. Cooley's a full-service law firm, international. We help clients with a vast array of services, including corporate formation, employment law, litigation, and of course, space and satellites, which is what I do. I represent a number of folks in the industry, some of whom you may have heard of, Planet Labs that does Earth imaging, and be remiss if I didn't mention Hawkeye 360, since my client's sitting in the audience. They do RF sensing, geolocation type services. Also a number of folks that are much smaller that you probably never heard of. Planet IQ that does weather forecasting by measuring the amount of diffraction in a GPS signal as satellites travel through the atmosphere. They can do that with all the GPS type satellites. So we do that soup to nuts, help them from startup to the end. My path to space is unfortunately not very exciting. So I'll skip that and just tell you why I still am in the industry. And that is, there's two primary parts. One, I love working with clients that are doing innovative missions, that are doing things that are not historically thought of, which is kind of interesting to reflect on, which we'll talk about later. But all these new innovative services are exciting to be a part of, and helping them accomplish their mission gives me a lot of personal joy. The other reason that I am in this industry, and I love it, which Ryan doesn't know yet, but I was an engineer wannabe when I went to undergrad. And so this is my opportunity to pretend I'm an engineer, work with a lot of engineers, and kind of explore the path that I almost traveled down. So.
Well, thank you all very much for those introductions. It's a fantastic spectrum of backgrounds that you all bring to this conversation. So assuming that most people in the audience are not lawyers, I know that we had wanted to kind of amongst ourselves just describe the different layers of law: international, national, private commercial, and then the interplanetary that Michael brings to the table. So with international, Glynn and Marlene, we're gonna start us off. Just kind of the framework. What non-lawyers need to know about international law?
Yeah, I guess I'll start. I think, you came up with a really good title, because there are a ton of layers of law here that you have to comply with. But we have to start with the international, and that's because when the whole thing got started, when the space race kicks off, it's governments. Government to government competition. There's not a private sector. I think even when the space race began and we started seeing a lot of international laws develop, the thought that a private actor would have the resources necessary to go to space probably felt a little far-fetched to the people at the time. So we have to start off at that international level. So I'll get briefly academic here, just for a second, I promise. So what is international law? So primarily what we're talking about when we're talking about international law are treaties and written agreements. There's another more complicated aspect called customary law, but space law is pretty brand new. We don't really have to worry about that yet. The primary laws that we're dealing with are treaties. And the first most important kind of foundational treaty is the Outer Space Treaty. The Outer Space Treaty is signed in 1967. And I think that piece of that date is important from a contextual standpoint. Because in 1967, so we've only had a few people go up into space at all. Only 4 nations have even launched a satellite. There's been no moon landing. But what we are in is the height of the Cold War. So when the International Space, or the Outer Space Treaty is first negotiated, the whole premise is, how do we manage the conflict between these two superpowers on Earth, the US and the Soviet Union? How do we manage that conflict in space as well? So you start to see, when you see that context, you start to see a lot of, oh, well, now these provisions in the Outer Space Treaty make sense. And it's not to say that they're not still applicable today, but they were written for a reality that doesn't really exist anymore. So what are some of the major principles that we're looking at? The first is, outer space has to be free for all, to the benefit of all mankind. There was a lot of concern at the time in 1967 that the US and the Soviets were just going to go into space, gobble up all the resources, gobble up everything. There's being nothing left for anybody else. So we wanted to prevent that. The second major principle is non-appropriation. You cannot claim territory in space. You cannot be a sovereign of a celestial body. Again, we're trying here to prevent conflict between the two parties. I think there was a recognition that the last time a major European expansion occurred, a lot of conflict resulted. We didn't want that to happen in space. We didn't want the conflict on Earth breeding, so we said no territorial land grabs. Everything has to be free for all to use. The third principle, and this one I still think is great, peaceful use only, right? Space must be used for peaceful purposes. No nukes in space, no military bases on celestial bodies. Again, you're just trying to manage that conflict, make sure it doesn't expand. The next principle I'd bring up very quickly is that of no harmful interference. Basically, the principle just means don't mess with their other countries' missions. Don't try to disrupt them. Have respect for them. Allow them to operate in a way that they can complete the mission. And again, you're just looking to manage that conflict between the powers in space. Make sure it doesn't spiral out of control. Now, that principle actually has taken on a renewed importance in the modern day because the United States is using that principle in the Artemis Accords to say, when we put our bases up on the moon, we can surround them with the safety zone to protect against harmful interference of our activities. China and Russia do not agree with that. They say that's unlawful appropriation, that's not allowed under the Outer Space Treaty. So there is conflict and disagreement there. And then for a lot of our private industry here, one of the most important principles of the Outer Space Treaty is that nations have to supervise the activities of their non-state actors. If you're a commercial entity, the government must regulate your business to make sure you are complying with the principles of the Outer Space Treaty. So regulation is coming. It's mandated by international law. What that regulation is going to look like, I think, is up for a little bit of debate.
And that was a great overview of the 1967 Outer Space Treaty. And that really, I agree, is the fundamental of what space law is. I'd just like to give just a broader context of where it fits within international law, where it came from, and where we're going. Because in order to understand, in my view, international law and its applications, specifically to space law, it's certainly a work in progress. And there's not too much certainty in those rules and those provisions. It's not like a slip and fall law that, A, B, and C, and D, and whatever elements are there, and then you can come to some type of conclusion. There's a lot of analysis that goes into understanding what space law is now, what it might be in a year from now, or 50 years, or 100 years from now. So yes, we began with the 1967 Outer Space Treaty when it was predominantly two states. Following that, we had the addition of 4 other UN treaties, so conventions that build a framework of what space law is and constitute this sense of international law. A convention that deals with a rescue agreement, also of liabilities, of registration, and then a moon agreement, which is very controversial at the moment. But these laws, I agree, these conventions did not envision all of the vast creativity of human imagination and technology and development. However, with any kind of law, the objective is for it to be able to expand and grow, but be able to use those bones, the structure of the law, to facilitate that growth. And the problem is that we're not growing, we're growing too quickly, I think, for the existing space law, and the UN has recognized this. The Center for the Development of Space Laws at the UN is the United Nations Office of Outer Space Affairs, which is part of the Secretariat of the UN. And the base office is in Vienna. And the work goes through the COPUS, the Committee of the Peaceful Uses of Outer Space, which meets in February on technical issues. In the spring, so next week, they'll be meeting on legal issues, and then in June on just generally policy issues. And so this is where the formation of the law, the discussions happen in a multilateral forum. However, because we're not moving quickly enough, the technology is expanding, especially since the U.S. law that was signed under Obama 2015-16 that allowed for U.S. investors to profit from their investments in space. And that really was a domino effect then through Luxembourg, et cetera, and that brought in massive amounts of investments and technology. And this is why now we're trying to catch up with the law. So what happens at the COPUS is important to follow. It's very slow. So other states have developed different mechanisms in order to facilitate their work. For example, the UN has created the Artemis Accords, which is a series of bilateral agreements that now has more than 50 partners. Bilateral agreements, they're not multilateral agreements. So this is exciting because it allows a lot of flexibility and more predictability. However, it's not a multilateral agreement, and then we get into the issue of public international law. So when does conventional law and customary law begin? And so that balance of what is the law, the written law or the custom, becomes an issue. And so we're really in that very delicate area. We also have a different group, the BRICS coalition. We have the Lunar Resource Agreement. So there are different groups that are developing that want to develop different rules and mechanisms to be able to move forward projects. So when you're thinking about making investments or undergoing a project, it's this ecosystem that must be thought of in addition to understanding what is happening. So it's not just what the law says, what individual states want, what their partnerships how they're developing, where does this apply, and also what industry is doing, and with which partners they're doing this with. So there's a lot of activity around the world. So before really trying to create an answer for a question you have, I think the subject needs to be identified, the type of technology, where the technology is being developed, where it's being launched from, where it's going, and then you can do an analysis on the rules. But all of that is quite complex right now. It doesn't mean it won't be complex in 10 years from now or 20 years from now. It was certainly less complex 20 years ago. But how is it that we figure this out? Is a lot of it comes from the development of international law. So a lot of the provisions that we see in the 1967 Outer Space Treaty, for example, one which is very important to keep in mind is that there's really none of this finders keepers, salvagers law that was existent in the law of the sea or international law, universal law of the water. That did not work well, and that's a provision that was considered when the 1967 Outer Space Treaty was being formed, and perhaps this is why we don't have that in space. So knowing this can help predict, can help foresee what the laws may be, and one of the other big issues in terms of business is liability and insurance, and that is something that is a big question for investors. They're not big answers yet. And so it's very important to keep an ear to what's going on in these forums. And another forum I think would be very good to follow is the International Astronomical Federation, which brings together academics, industry, states, agencies, the UN. So that's a great forum to hear collectively what the discussion is and to take a temperature before moving on to the same and understanding more in the year ahead. So that's my bit. Mm-hmm.
Thank you very much, Glynn and Marlene. I think Tony's going to give us a national overview next.
Thank you. I'm going to echo what Glynn said earlier about a great title, The Layers of Law, for this. I don't know if you guys can see the list of questions, probably not. But anyway, very appropriate. So I think to understand how the laws work in space, it is important to understand first the international framework. There's a series of treaties. These guys did a great job of covering them. So then there are national laws that's country specific, like the US or Russia or China or the UK. They each have their own set of laws that govern space activities for their citizens and companies. And a lot of those laws, a good portion of them, are influenced by those international treaties. And so like at a high level, Outer Space Treaty Act, there's one major item on there is that the state is responsible for objects they launch. So that in itself forces the US to adopt certain national rules that govern being responsible for the actions of their commercial entities. So there is something known as essentially the Space Object Registration, which means if you are a company launching a US satellite, the US has to be responsible for your satellite in terms of responsibilities or whatever happens out there or whatever happens if it comes back down to the Earth. So that's kind of number one. The other one, which is kind of a corollary to this, and it touches on a little bit what Glynn talked about earlier about non-harmful interference, is the use of spectrum, radio frequency spectrum. So just kind of taking a step back, if you probably haven't given this a lot of thought, but to do anything in space, you need to be able to talk to the satellite. You need to be able to tell it what to do. And the only way right now, current technology, is to transmit commands via radio frequency waves and receive similar feedback on the way back down. So in order to do that, you need to get a license. And you need to get a license from a country that will support what you're doing. So that brings in the national laws. How do you get up in space? You got to go to a country. Doesn't matter which country. Even if you're a US company, you can go to France, you can go to the UK and get a license to do space operations there. And so that's kind of the context of how the laws, the separate laws work. And I'll stop there because we'll talk more about the specific laws later.
And then heading further down, I guess, the layer of law, Neha was going to fill us in on some of the private and kind of commercial aspects to the legal regime.
Right, so the commercial aspect, and I again want to reinforce that the layers of law are very important here because they all inform expand and constrain each other somehow altogether, right? So you have to understand each layer. Even if you're a commercial space lawyer, you do need to understand how the international law space ecosystem works, how that impacts the national and regulatory schemes. And then the private layer, that is the backbone, that is the lifeline of what I see happening now in the space industry, because for a very long time, it was almost all government infused and government-led projects and missions. But now we have commercial space and new space, which means you need to pay attention to, yes, contracts, intellectual property protections, and disputes. So I like to think of the private part of it as 3 core layers that are very much a part of the larger layer of everything that's happening in space. So you have your contracts, which are, you can look at it as external and internal, and I'll expand upon it later. Your intellectual property protections also go hand in hand with that, trademark, patents, and trade secrets. And then you have your disputes. And again, these 3 layers are not independent of each other. They build on top of each other. The person who is advising you on these layers needs to understand not only the larger ecosystem, but also how these 3 layers interact and rely upon each other to help you grow as a company and help you sustain in the long term. Because if something goes wrong within the commercial and private layer, that could have long-term legal consequences and really just destroy maybe a brilliant idea that you had in the space industry. So not to be the negative person here, but that is my job. It's what I've done for a very long time as a litigator, is to advise clients on finding out where the risks are and how to mitigate them. And, if it happens to be so that Tony is the one who's going to help mitigate a specific risk on the regulatory level, the person who's advising you should be able to tell you that and explain that to you, because you're not going to get one person who can do everything within the space industry. And if you do find that one person, don't hire them.
Excellent. Thank you for that. And I know we've all been talking about the complexity and all the interacting dynamics. And so to make things even more simpler, we're going to take this entire regime and make it interplanetary.
Thanks. What we're trying to do with the Lunar Development Cooperative is fill the gaps that exist in the legal framework for space right now. So like as the other panelists were mentioning, nations can't just go up to space and say this land is ours now and therefore our laws will apply there. So in order to build an effective legal framework requires some form of international cooperation. The problem is, if you've ever looked at an international treaty, you know that they normally, at best, don't go much beyond these high-level kind of principles about what people should do, and that are often not legally binding and not enforceable. So the problem with this is an economy needs clear rules that are binding and enforceable on everyone. That's the only way property rights works and environmental law and so forth. So what do we do about this? Well, I don't think there's any question now that we're going to get some new multilateral treaty, especially one that is that agrees on very detailed, specific rules. And even if nations did do that, I'm not sure it would be a good idea what they would come up with. So our solution to this is by looking at a variety of contexts throughout history where people have developed enforceable legal systems without a state creating them. You can look at fisheries, the early rise of mining rights. These were all sort of privately constructed legal frameworks by agreement among people using a resource. The development of commercial law all originated from merchants just sort of agreeing what the rules would be and hiring people to adjudicate disputes. Maritime law is similar. So drawing from all of that, what we came up with was to create an infrastructure and public service provider known as the Lunar Development Cooperative. And this would be co-owned by the private sector and by as many nations as possible from around the world. So up to 49% of its ownership, its equity, would be bought by as many nations using things like sovereign wealth funds and other investment vehicles, and 51% or more by as many individuals and companies. We want to make the shares available on a universally accessible platform so that literally every single person on the planet can become a shareholder. We want to make the LDC humanity's holding company for the moon. So what this infrastructure provider then does is provides the kind of the foundational shared infrastructure that's needed to support an economy. On Earth, we have airports and seaports and postal services and roads and yada, yada, yada. The equivalent of that in space might be a landing pad on the moon and roads and emergency services and shelters, backup supplies, information on lunar resources and terrain and so forth. So the LDC would be providing these, but in order to create this enforceable legal framework, they would say these services are only available to people who voluntarily become members of the LDC. And becoming a member means forming a contract, a legally binding contract with the LDC that it obligates people to certain rules of conduct, what you can do in space. And these rules could cover labor, environment, harmful interference, and all of the kind of gaps that we have currently in our regulatory framework. The entire structure is voluntary, so companies can join if they want to, or they can't. But in order to use the infrastructure that the LDC has built, they have to become contractually bound to the rules. And then those contracts could be legally enforceable in a court of a designated nation on Earth that's selected in the contract, or an international arbitration panel. And the contract would allow for, if somebody violates the terms of the contract, for the LDC to impose fines, to cut them off from certain services, and to sue them in a court or international arbitration center on Earth. There's a lot more to it, but I'll stop there.
Excellent. So now that we've kind of proceeded up and down through the layers of law and given everyone kind of an introduction, we're going to get into the relevant questions. So I'll just kind of outline what the five of them will be discussing, and then just kind of let them dig into the details a little bit. So Tony's going to talk to us about the regulatory universe. Neha's going to talk about contracting disputes, IP protections. Marlene's going to talk about international markets. Glynn's going to talk about the volatility and evolution of space law. And then Michael's going to talk to us about governing off-Earth economies. So I know that all of you had alluded to the details you wanted to get into. So now I guess we'll start with Tony and kind of let them go from there.
Thank you. Yeah, so this is a kind of a little look into my day-to-day life as a space lawyer from a practical perspective. Like, what are clients calling about? What issues do they face? So as we talked about a little bit earlier, my focus is on helping space clients get the licenses they need to operate in space. So from the U.S. perspective, assuming you're a U.S. company and or doing business in the U.S., you have three main agencies that you deal with. The FCC, Federal Communications Commission, and that is for the RF license that we were talking about earlier. You got to communicate with your satellite. Then there's the FAA. FAA really primarily involves launch vehicle operators trying to get into space, but there's also another hook that the FAA has on everybody else, and that's called the payload review, which means if you're a payload on a rocket, the FAA is allowed to review you to determine if you comply with the public interest, but it includes national security. So it's a very real threat or review, if you want to call it whatever. And I have seen launches get delayed or stopped as a result of that payload review process. Then the last agency is NOAA, the National Oceanic and Atmospheric Administration. And NOAA provides satellite imaging licenses for U.S. companies that image the Earth. So it's a very niche area. If you happen to take pictures of the Earth, you are regulated in theory by NOAA. This is actually, it's a little bit more refined now, but back in the day, NOAA took the position that any camera in space is subject to NOAA jurisdiction. They ran into a lot of issues because there were a number of launch providers, one you can think of in particular, who had put cameras on their launch vehicles and were showing these publicly to anybody who wanted to. And then NOAA said, wait a minute, you should have a license. So they sorted all that out and decided that, well, if you're doing launch vehicles, you don't have to have a license after all. So subject to change, but NOAA has that kind of niche authority to license you if you have a camera on your satellite or any object that's in space. So the usual type of questions I get are very nuts and bolts, as you might imagine. hey, Tony, I've got this great project. I want to go to the moon and extract some minerals and bring it back to Earth. I want to file an FCC application so I can communicate with my lunar lander, the mining device, and the object carrying, getting us there. How much is it going to cost me, and how long will this take? So those are the same questions for NOAA if you're, doing a satellite mission that involves imaging. So I usually give this straightforward answer because that's what they want, very business-oriented, nuts and bolts. File 9 to 12 months in advance, and then I break down the fees. Probably not that interested in the fees, but I'll give you the high level. For NOAA, everything is free, in air quotes, meaning NOAA doesn't actually charge you anything for it, but you have to invest time in filing the application, answering questions, drafting a narrative, all the kind of good stuff that goes with filing any kind of regulatory document. FCC does, however, charge filing fees. Historically, they were actually extremely high. The application fee for a non-geostationary satellite 10 years ago was $400,000, which was, think about it, a lot of money for a satellite startup to invest in a company for just the application. They have since changed that, and they also created a kind of streamlined easy pass, if you will, where they reduced the fees down to $12,000, give or take, or maybe it was 10, and made it a lot easier for folks to get through that process. What they didn't realize is later on, they also changed their annual regulatory fees and increased those to an exorbitant $400,000. So they took with one hand and gave with the other, and ultimately it ended up being the same place. Pretty expensive for a startup. So those are the questions I normally get, and those are my usual answers. There's a number of these other questions too, which are too complex to explain in this one meeting, like which spectrum do we use and that type of thing. But I wanted to caveat this because whenever I hear those questions, I do get the sense that folks are thinking about their regulatory relationship and the regulatory world in the wrong way. It's, the way the questions that are asked and the way and what they're asking suggests to me, hey, I want to purchase some software. How much does it cost? I want to purchase this FCC license. How much does it cost? And it's not quite that simple. So the one thing I always try to instill in clients is that the item you're purchasing or the item you're dealing with is more like a relationship. Those are, the FCC, NOAA, they're more like investors in your company. Yes, you have to pay a fee. Yes, you have to fill out a form, but you want to treat them like they're an investor and you want them to be supporters of your activity. And it gets harder and harder as there are many more space entrants in the field. But early on, when there was 5, 10 new companies a year or every 2 years even, they got to know every single company that went through the FCC to get a license. And they would know what your mission was about. They would know everything about you. So I still encourage that. I think it's important that folks realize that licenses and items you get from the government are not off the shelf. They're not inputs to your output. It's more of a relationship and something you have to commit to informing and entrusting them in some way as well. I'll stop there.
We're doing excellent.
Ask one of your questions.
Yeah, no, please go ahead.
I was going to ask about the 5-year rule, and we sort of did cover that in our prior conversations. I think it's of great interest, and perhaps it might be of interest to the audience. Can you talk a little bit about the rule itself, the 5-year disposal rule, and how you're seeing it play out in your practice?
Yeah, sure. Happy to do so. So the FCC a handful of years ago, and it came into effect very recently, implemented the 5-year disposal rule. This touches a little bit of just more background here, sorry. International law requires that satellites in space that are coming back to the Earth demise within 25 years. And that was the old rule that the FCC had. So you had, I'll say, a lot of time before the object came back into space. But recently, the FCC said, no, we're going to make this big change with no input from folks like NASA, who are the real rocket scientists, but they changed it to 5 years. They say, well, we're going to declutter, and we're going to start with objects that are going up in the future. So that was the rule. It was effective, I think, as of September of last year. Although in reality, they started enforcing it years before it became effective. And I can tell you later about the offhand way that the FCC enforces rules that don't actually exist. But the upshot is it hasn't been that big of a deal. And there is the folks that run into the 5-year deorbit problem, I mean, basically it caps the number of years after your mission is over by which that satellite has to demise and enter the Earth's atmosphere. So instead of 25, you have 5. So what it forces folks to do is to actively bring down their satellite at some point to ensure by the time your mission ends, that satellite will demise in 5 years. The hard part about all of this is actually the ensuring at mission's end that there will be 5 years left. So the secret, if you will, is to make sure that there's a natural gravitational pull. So when your satellite no longer functions, the gravity will pull it down at some point. So you can calculate what that time period is, and you could just bring your satellite down, I'll say early, and keep it operating at that level until it stops functioning, and then essentially you've ensured that you can meet the 5-year deorbit. So the drawback is you have to calculate, well, when is that period? How long do you expect your satellite to be genuinely in operations? For instance, you could estimate, well, my satellite could be operating for 10 years, or it could die earlier at 5 years. So you have to make a realistic calculation, because if you guesstimate 10, and it fails at year 5, you may be at an orbit that is too high for it to naturally demise in 5 years. And the FCC has said, although they haven't enforced anything because the rule is too new, that they will start enforcing folks who violate the 5-year rule. But the jury's still out on how they'll do that, what type of penalties they'll impose. So we'll see.
Thank you for that. Go ahead, Neha.
Thank you, Tony. So getting back to the private layers of what we were talking about earlier, I don't really want to theorize on, what should be in the contracts or, what you should be doing in terms of IP or disputes. We'll get to the IP layers later, but I want to just talk about a case study and specifically a case. Initially, I was going to talk about an older case related to a lunar spaceflight purchase agreement that a gentleman had agreed to pay $150 million for, and it ended up in federal court in Virginia. But you guys can look that up on your own, because I found a newer case that is sort of hot off the federal dockets involving a major commercial space provider, who sued a former executive in federal court. This was probably around less than a month ago. This former executive exported several confidential files and data and information right before leaving employment. A few months later, this individual joined a direct competitor of the company who is the plaintiff. That's the plaintiff in the case. And again, I'm not going to get into the names. These are, federally, publicly available materials, but I just don't want to put any particular individual or company on the spot. So you're free to go look up the case on your own. I'm sure you'll find it. What I want to take away from this case, the case is currently pending. There's a motion for preliminary injunction. It's currently pending in federal court. So we don't know what's going to happen with it. But what we do know is what has happened and what are the questions and takeaways that we can get from this particular case, right? This is a major company, so they had very good agreements in place. They had a confidentiality agreement that included a non-compete clause, a non-solicitation clause, everything. It was a very all-encompassing, sweeping agreement, and yet this happened. And my point in saying that is, even if you do have contracts in place, this happens, and it happens to the best of the companies, right? So if you're a smaller startup company, you definitely have a strong interest in putting these contracts into place early on, and that's the best you can do. No, it's not. How these contracts play out is also very important, because what happened here is, yes, they had a very good contract, but could there have been something done better in terms of exit strategies and protocols if the company knew that this individual was leaving? These are discussions that need to happen with legal counsel, right? It needs to happen with legal counsel, with the other executives in the company, with the IT department, because sometimes these things fall through the cracks. Okay, this person is leaving. That's that, right? No, you need to be a watchdog. You need to be a watchdog of your own intellectual property, of your own contracts, of your own employees. And in terms of that, you have to constantly be proactive in the type of legal advice that you're getting at all levels. And it does not matter whether you're a small company, you're an early stage company, or you even just have an idea. Very important to look at the details. So that clause was there. Whatever happened, happened. Now we take a look at the dispute resolution part of it. This particular agreement has a mandatory arbitration clause in it. However, this case was filed in a federal district court. Well, that's going to be a struggle that some lawyers are going to have to deal with who are involved in the case. There were probably some strategic decisions made given the nature of what happened here in terms of why it was filed in federal court and, why there was an arbitration clause. So take a look at boilerplate clauses. That brings me to my next point. Take a look at boilerplate clauses closely, because even if you have an attorney drafting a contract for you, you want this person to understand you, your business, your objectives, where your risks lie, and based on those things, you want to get a customized contract, right? Do you want a sweeping arbitration clause? Do you want a sweeping litigation clause? Or do you want a tiered structure that works for your business if there is something that goes wrong? And more often than not, things will go wrong now more than ever, because we are in a place right now where new space, new companies, commercial space are just coming up on the forefront. So there are going to be more commercial disputes of this nature going forward. So take a look at these things very closely and hire counsel. And a lot of times startups come up to me and say, I can't afford to have in-house counsel. I can't afford to have the big firms. They're very expensive. Well, my advice to you is seek out, there are folks who do fractional general counsel work. There are folks who will, you'll find good quality lawyers out there who are in this space, who understand the ecosystem, who have seen how contracts play out in real life, and can give you the good advice on those ends, on those fronts. The other thing I would say is there should be clarity in the contracts, right? You have to understand when we talk about external contracts. So internal, you have to be like a watchdog of your own company. When you look at external contracts, there has to be clarity. Oftentimes what I see in the space industry is there's a lot of technicality, like technical jargon, engineering terms, hardware references. And just because the contract contains all of those things does not mean that it's legally strong and legally sound. So you really want to have somebody on your side who can see where the risks are, who can vet the other side for you. You need to do your due diligence on these things. So just because a contract contains all of the things that perhaps your engineering team is happy with does not mean that it's going to play out favorably if something were to go wrong. So take a look at all of these aspects when it comes to contracts. There was one more point I was going to make on the contract side. Clarity is good. I'm going to contradict myself just a little bit. Clarity is good, but strategic clarity is even better. So just make sure that you, when you do talk to an advisor or counsel, that you do give them the nuance of your business, your objectives, where you see yourself in 5 to 10 years, because all of this information is important. And touching upon what Tony said earlier, right, in relation to the FCC, you're not really paying so much for the license, it's the relationship. So work on building a relationship with a person who can work with you long-term and who understands the ins and outs of your business, your contracts, your partners, where your weaknesses lie, where your strengths are. Now, on the IP side of things, and this goes for contracts and IP, get the advice early. Get it sooner rather than later. Reach out, reach out to attorneys, interview them. I encourage people to do it. I've worked with many startups, not necessarily in the space sector, for many years, and almost always they come to me too late. So the branding has already taken place, and now there's an issue that we cannot file for a trademark because there's a conflict. Well, folks spend a lot of money on marketing, on branding, on websites. Once those materials are out there, it's now in this digital age even harder to replace it and go back and redo it. So get the advice early on the trademark side of things. It's not very expensive. So I highly encourage everybody, trademarks, it's very easy. Go and get the advice early. On the patent side of things, I'm not a patent lawyer. However, I'm currently working on building an IP analytics company that is going to provide advice to space sector companies on where their inventions lie. So oftentimes what happens is you have a group of engineers, they're working on a brilliant idea, but they're not necessarily patent fluent, right? So they don't know where they have a patentable idea or where it might even be something they've never even thought of. So they may want to bring in a company that can provide them with the insights and analytics that are drawn directly from the USPTO website, which can inform them, hey, these are your potential competitors. These are the types of patents that are very close to, to what yours are, and these are the areas where you have a solid chance of getting a patent. And then once you get those analytics, you can make internal decisions and then hire a patent lawyer to file the patent for you. So again, patents are very important, and protection of trade secrets. Again, that goes into contracts and disputes. If you have basically given so much time and effort to creating an idea and building it up with a group of engineers, make sure you're protecting it on all of these fronts, on the contract level, on the disputes level, patents, trademarks, and trade secrets. Due diligence is key no matter who you're working with. I always say trust is very good, but verification along with trust is even better. And that is how I would sort of sum up the entire private layer of things.
Excellent, thank you. And then I know that Marlene's going to talk to us a little bit more about international markets.
This subject is a very exciting one for me, especially because of how I see the markets playing out currently and where there are opportunities. So it's a large topic. So I'll just mention a few of the opportunities in case anyone's interested, and also help create the context of where these opportunities are, especially outside of the United States. So there's a lot to do with space. People are very creative. They're very passionate. And it's amazing to see the bounty of human creativity work together and utilize what we've developed in the last thousands of years. Those visionaries that can see into the future and get going on projects that are really fantastic. So I guess to begin with, this idea of space spin-offs. I don't know how many of you are familiar with them, but they're types of technologies that are developed in space because of microgravity and other physical qualities, which I'm not too tuned to because I'm not in the sciences myself. But it's really amazing to know that, for example, a contact lens solution or our mattresses, a lot of different products that we use on Earth, like exercise machines, those technologies were developed in space, and they're called space spin-offs. So those are a great market for investments, and they can be sought out through different experimental processes, opportunities through payloads that go up into space. And this can happen not necessarily just from payloads that leave the United States, but they can be payloads that leave from other countries. And once they leave from other countries, there are other regulations that may apply to them. And some may be more beneficial or less advantageous. So it's a question of researching. Then there is a huge market for spaceports. So we know what airports are, obviously, and they've popped up all around the world. But now we're seeing the development of spaceports on different parts of the planet, and different spaceports. They have different characteristics that are more beneficial than others, depending on where the spaceport is, whether it's like on the equator, on closer to a pole, like in Norway. So those are opportunities outside the United States. Then there's a lot of opportunity with capacity building. So some states are very advanced in their space capacities, and they work with other countries, not only at the state level, but with companies, with schools to help develop research projects, and then send them off into space for them to be tested, and then for products to be developed. And so that's a great investment opportunity. So one country that comes to mind, which is very strong in this area, is Japan, for example, and their space agency, JAXA. And they have a great office in DC. They're very open and willing to work with civil actors, so people who are non-governments. And the programs are very well structured. I would say there's a lot of predictability because they're often run through the UN. And they also offer an opportunity for a greater audience, a greater group of people, not just a small group of investors, but people all over the world. And so that's one thing. Maybe on a bigger scale, our satellites. Satellites are instrumental. I mean, without satellites, my friend who used to run JAXA said, it would be catastrophic, and it really would be catastrophic. But the idea of satellites and who owns most of the satellites, that is one big question, whether they're privately owned or publicly owned, and who owns the market share. Now, the problem is that satellites offer many benefits that we all use, whether it's weather, communication, Earth observation, space technology. So these satellites are essential for the development of any national infrastructure. And that's built into the UN Sustainable Development Goals for 2030 and each regional goal for different parts of the planet moving forward. So space technologies, they really pivot from the satellites. Now, this idea of satellites and being able to lease or get pictures, get services from the satellites is great. And so there's a group that really would like to commercialize access to satellites. And that's wonderful until the access is not there anymore, whether because of a scientific, technical issue, because of a political issue. So many countries around the world who are not spacefaring quite yet, or who are working on becoming spacefaring, want their own satellite. So in order to help bring them their own satellites, that is a large industry that's developing, especially in Latin America, to help emerging space nations obtain their own satellites. But then there's a lot of disagreement about, well, there's not enough space for your satellite, so you have to go with a commercial service. So that's part of the discussion at the international legal level. But this access to space technologies is essential. And then there's a bunch of really fascinating type of research, whether it's medical research, materials research for textiles, for medicine. And that can be a great investment through universities or private companies. And there are a lot of really extremely smart and fascinating people all over the world. So there are opportunities here in the U.S., but please keep in mind there are opportunities outside the U.S. and very eager individuals that are looking for investors to help develop these space technologies. So that's my, I guess, very brief spiel on where the international markets are.
Well, thank you very much for all of those different kind of deep dives into different components. And then I know that Glynn's going to talk to us about how volatility kind of underlines all of it.
Yeah, and I want to start by echoing something both Tony and Neha said, and it was almost the first piece of advice I would give a lot of my clients when I practiced, particularly startup clients, and that was know your regulator, build a relationship with them early. Because when things go wrong, and things always go wrong, it is best to have somebody who knows your business, who knows your intention, who can work with you to solve a problem. The problem for us in the space industry is that there's not just one regulator to know. We're kind of like in a polygamous relationship. We've got multiple regulators, as Tony said, the FCC, we've got the FAA, we've got NOAA and the Office of Space Commerce under NOAA starting to take more responsibility. So depending on what you're doing, you might have to be satisfying the needs of more than one regulator. And that presents challenges. And on top of that, there are even parts of space now that we don't have regulators for. We're still trying to figure out in this Congress, who is going to regulate what are called novel space activities. And there has been some proposals. We've gone back and forth. The first Trump administration favored putting all of that responsibility into the Office of Space Commerce. The Biden administration preferred a more decentralized approach. It's not quite clear what this Congress is going to do. They're still kind of bickering back and forth about who's going to take charge of these novel space activities. What do I mean? I mean things like orbital debris mitigation. We know that there's a lot of thought that goes into this idea of, well, how do you stop new debris from being created, including the 5-year rule that Tony was discussing, other international standards. There's not a great standard yet or a great regulator for what do we do with the debris that's already up there. And as Marlene said earlier, the problem is there's not a law of salvage for space. Technically, if you find a piece of debris under the Outer Space Treaty, you're supposed to return that to the launching state. They are the owner of that piece of debris. How you do that when you pick up a small little piece of micro debris is almost impossible. Right.
And it's not yours under the law, you may just suppose.
And it's very difficult for private companies to come up with solutions. And there are a lot of private companies coming up with amazing engineering solutions. But legally, how do you take that risk? How do you, as a private company, say, I'm going to go up and clean up space debris, knowing you could be exposing yourself to liability? So we need to come up with a legal solution that kind of prioritizes this, because everybody agrees orbital debris is a problem, and it's only getting more and more crowded up there. And there's numerous other novel space activities as well. Why do I focus on this? And this is kind of, I guess, your homework assignment as industry people. I focus on this because the current rules, the current regulatory regime is being written. Right? It is happening now in Congress. And what most people don't realize, or maybe don't understand fully, is that you have a right under our Constitution to participate in that process. The First Amendment gives you a right to petition the government. That means you can go and tell the government what you want them to do. Now, they don't have to listen, but they do have to, or they don't have to agree with you, but they do have to listen. They do have to take it into account. So every time a regulatory agency wants to come up with a new regulation, they have to issue what's called a notice of proposed rulemaking. It's required under the Administrative Procedures Act. That's your opportunity as an industry to get involved, to say, we want you to do this type of regulation. We think this other type of regulation is too burdensome. This is when they're taking testimony. This is when you can file comments. And filing a comment can be very easy. I have my students do it every year. We go on and we file comments together. It's just on the website. File your comment, type it out. Obviously, as an industry, you can be a little bit more grand in putting together your comments than we do as my students, but it is open process to you. So what I would say to people in the industry is don't give up your seat at the table. Make sure you're participating in the process, file your comments, and have somebody, either someone you hire, somebody at your organization, who's tracking the legislative process, who's following along and making sure that as a business, when you can submit your comments, when you can lobby your government, when you can talk to your representatives. And I would say this too, talk to your congressional representatives. When you go in and actually talk to your representatives about the reform that you want to see, it is much more effective than you think. Every person that comes into their office, they assume 10 other people are behind them who have the same concerns. And don't believe that, somebody else will take care of it. Because other people are participating in the process, but they may not have your interests at heart. They may not have the same viewpoint as you are. So it's on you guys to make sure that you are represented in the process.
Excellent. Thank you so much for that. And as with the previous section, we've discussed all these different particulars, all the different volatility, and now we want to take it off of the planet. So, Michael, how do some of these different areas impact your line of work?
Is that on? Okay. So take an example of what something that's likely to happen on the moon under the status quo. So we know from thanks to the Artemis Accords and a lot of domestic legislation, that you can own what you mine from space, but you can't own land, at least according to the way most people interpret the Outer Space Treaty. So this creates all kinds of what economists call tragedy of the commons potential problems. Let's say you're a mining company and you want to go mine resources from part of a permanently shadowed region, and you invest billions of dollars there. You can't, because you don't own the land, you can't stop someone else from mining the same spot. And so that means you will race to take as much as you can before someone else, which probably means you're going to use the resource less efficiently, and all kinds of environmental hazards might come from that. Now, the Artemis Accords offer you an interesting idea here, which is to claim a safety zone, saying that no one can come near you. But there aren't really good rules around how big that safety zone can be. So in theory, somebody could use it to claim a vast area and essentially monopolize a whole region of the moon. So an example of so this is a great example of the kind of thing that the structure we're building with the LDC framework could solve, because what the LDC is in a position to do is offer to its members a site use registry. So if you want to go use a particular part of the moon for a particular purpose, you can record that in the registry. So you might be building a research base, or converting a lava tube into a habitat, or mining water from a part of a permanently shadowed region, or oxygen or helium-3 over a broader area, or building a refinery, a variety of different activities. Once you've recorded those in the LDC registry, every other member will be bound under their membership contracts not to interfere with you. And there'll be certain terms about what constitutes interference and what you can do and what you can't in different situations. So that gives the member contractual rights to carry out their activity without interference. But this isn't a normal property rights registry that's conferring ownership over the land. That wouldn't be allowed under the Outer Space Treaty. But what it is doing is it's saying it's protecting an investment that somebody is making in land without anyone actually owning the land. And there's a number of examples of registries, property rights regimes like this, with fisheries and timber and other things that have been used, grazing rights and so forth. So and those rights could become marketable, so members could buy and sell them with each other, and you could actually have a value assigned to them. But you might be saying, well, yeah, but what about non-members? How does the LDC protect its members from parties that aren't bound to the LDC's rules under a member contract? And one way in which we'll be dealing with that is by clustering infrastructure at certain service hubs. So let's say the LDC's built a landing pad and power and roads and information and resources and terrain, perhaps a closed loop biological waste recycling network between habitats for keeping ecological balance. All these things that make it much easier, cheaper, and safer to plug into rather than to build it all yourself. Well, let's say there's a bad actor that comes along and they want to mine resources in a really destructive way, or use, abusive labor practices, using kind of a trapped labor force that can't get away on the moon. And so they know they don't want to become a member because their contract would force them to improve their practices, and they could be legally liable if they breach their contract. So where are they going to choose to operate? Well, if they go near the LDC's service hub, they're going to be having to build all of their own infrastructure, and it's going to be you're going to have constant conflicts with the LDCs. Now, they could try to just seize control of the service hub by force, but the LDC is going to have built-in security measures to protect itself and its members. And because it's going to have so many nations as investors, this would provoke major international backlash. It would be more likely, I think, that they would go off to another location farther away where they can build undisturbed. But at this point, most non-members will realize that it will actually be more profitable to just change their practices and become members. But even if there are some parties on the moon that really want to go it alone, they're more likely to operate further away where the risk and the severity of interference with members is going to be quite a bit reduced. So there isn't like a legal way in which the LDC can enforce rules against non-members, but it can design its infrastructure in ways that for practical purposes, members are going to not be interfered with by as much from non-members.
All right, thank you very much for that really interesting kind of zoom out. So now we have about 15 minutes left. I know that based on our planning conversations, all of you had some kind of interesting future ideas or future thoughts that you just kind of wanted to be able to discuss. If you have questions or comments based on how everyone else has presented, please feel free. Yeah, no, sure, go ahead.
So I'm going to follow up on what Michael said about mining on the moon, right? So if it's a question for all of the panelists, and I think it's an interesting one, is if we have the Artemis Accords, yes, but not everybody is, as you mentioned, they're bilateral agreements, right? So not everybody is a party to this. Not everybody agrees with the position that's taken with the Artemis Accords, and you mentioned certain bad actors. So if there's a company that wants to mine in the moon and they're trying to get investors, then the investors are like, well, you can't have safety zones when it comes to these certain bad actors. You can't exclude them. You can't have priority rights. So how do you expect me to invest in this venture? And then a larger question that I'll pose, and again, I think this is more just to have like food for thought. It is a space conference, so I love this topic as well. The larger question is probably for Marlene and Glynn is, do you think that there would be a soft law option in the future? Because clearly technology is outpacing the international frameworks, and we're not going to get to another treaty. But do you think that there is a possibility of a soft law option where countries could come together and say, these are the rules that we're agreeing to abide by because we all want to mine on the moon, including some of the bad actors, so-called bad actors?
Sure. I mean, I guess what I would say is, and I'm probably fairly alone here, I'm not as pessimistic about the potential for another international agreement. 1967 was not exactly a time of harmony here on Earth. We were in a position where nuclear catastrophe, nuclear war was very much a possibility. So, the thought that we couldn't, possibly come to another agreement on space to deal with something like mining on the moon where everybody's going to have interest, I'm not convinced that we can't do it. It's not likely. But again, I think if you were to ask somebody in 1966 whether the Outer Space Treaty was likely, they probably would have said, no, that seems unreasonable given where we are. I think the Artemis Accords are an attempt at creating sort of soft law. And, I think what's interesting is to the extent that we go to the moon, if there is no treaty, we go to the moon, we start setting up these safety zones, the U.S. sets them up. I mean, there's a real chance that starts to morph into some sort of customary law and becomes something more than just kind of a principle. I tell my students that we have to plan for these things or else we're just going to have a fait by fait accompli. It's going to happen, and it's just going to, once it happens, it's going to be very hard to pull back. Safety zones to me are a really big question. I think about a safety zone and the idea that, you put your settlement down, you surround it by a safety zone, and then you start to see that safety zone kind of spider web across the lunar surface because humans need services. We've got the place where we're extracting the minerals, but we need a place for our humans to sleep, and we need a place for them to eat. So we build barracks and a mess hall, and then we need a place for them to relax, and so we build another building, and our safety zone begins to expand greater and greater. And at some point, a safety zone just becomes a city. And at what point do you have a de facto appropriation, even if, legally you're saying, well, we're not sovereign here, but, we have this safety zone that excludes other people. Listen to Michael, I love his idea here of the development. And I did have a quote that I used in one of my things. One of my favorite quotes from about this topic is actually from Lyndon Johnson. Before he was president, he was in charge of U.S. space negotiations. And he says, today outer space is free. It is unscarred by conflict. No nation holds a concession there. It must remain this way. We of the United States do not acknowledge that there are landlords of outer space who can presume to bargain with the nations of Earth on the price of access. And I thought that was such a powerful statement coming from the U.S. that this idea of non-appropriation is really a U.S. idea. But in thinking about settlements, I was giving a talk on this issue out in Denver last year. I kind of sardonically quipped, while space may not need landlords, perhaps we need a co-op board. It's really exciting to hear, Michael's idea, and I read his white paper. I'd encourage you guys to do that as well. It's a fascinating idea because the idea that international cooperation could lead us to a better place, that we're avoiding conflicts with bad actors as much as we can, that, we have the weight of a number of nations behind something like a cooperative. I think we can hope that pushes us towards more of a peaceful solution than open conflict.
Yeah, and I don't think that the Artemis Accords are bad at all. In fact, I think they're a really positive step in the right direction. And with things like safety zones, the only thing that we have to have is a little bit more specificity about how you prevent interference, how big the safety zone could be and in what circumstances. And the structure that we're trying to develop with the Lunar Development Cooperative is having an entity that has the ability and the incentive to draw those boundaries appropriately. So they're not overly wide, so they're not giving people monopolies over huge regions, but are not too small so that interference is happening all the time. And one of the things that I hope, in fact, one of the goals of the LDC is to help determine what types of a broader legal framework is needed for space by sort of experimenting with what works within the LDC and what doesn't. This is how commercial law evolved in the Middle Ages and maritime law. It's like these, in that case, merchants or people, ship owners would sort of determine the rules that they would all operate under. And that, same thing with mining camps. Mining camps in the American West started developing rules about how extensive a mining claim could be and what rights you had for what period of time. If we've got something like what we're building, you've got an entity that can sort of coordinate the development of these standards and norms, and gradually they become more and more settled, and they become customary law over time, and then maybe they can inform the hard law eventually. So the part of the goal here is to sort of help influence and guide in a positive direction the development of international law for space.
Okay, so thank you very much for that question. I think it's a really fantastic question. It sounds so multidimensional and broad. And one of the observations that I'm making is in our discussion is we're looking at that question from one perspective, and there are many, many, many other perspectives from which people all around the world would answer that question. So there are people, many people, that think that the moon should not be touched. There are many, many countries that think that there should be no mining on the moon. There are countries that think that there should be mining, and like you mentioned, Michael, they'll have to get there and get as much as they can, as quickly as they can. But there are discussions. I was on one this morning about sites of scientific interest, about being able to identify sites where no one can go because the information there is so valuable for humanity that although there are some industries that or some companies that want to get there, how do we balance out all the information that can be valuable for humanity between now and who knows when? So there's a leverage in that discussion in terms of safety zones. Yes, Section 11 of the Artemis Accords of 50-something bilateral agreements, which means each of these agreements could be tweaked. Okay, it's not a multilateral agreement. Someone sees a safety zone, and that could be a big red flag to the other about 90 countries around the world to say, no, there are no safety zones because that's appropriation. And then if you think about how you're going to protect these areas when there's access and then even defend these areas, then that's another large discussion that many countries just don't want to go in. And it's not that I want to advocate for one side or another side. What I just want to make very clear is that we're in this room and we're going to be having these discussions, but expand the room or put it in another city, another place of the world, and the discussion will be very different. And so we have to ask, which is the valid viewpoint, okay? And then one thing that I mentioned early on is that before taking steps to move forward, history really is very, very valuable. Maybe we won't mimic history, we make it detail by detail, but we can learn a lot about history. And so I will share one example with you. It's just kind of to keep it in the back of your mind. And this has to do with the law of the sea. And so as you mentioned, Michael, this idea of maritime law, how it developed, countries were far apart. There wasn't Facebook, there wasn't telephone. So there was this custom that was developed, which eventually was formalized in the 1982 Law of the Seas Convention, which encapsulated a lot of the do's and the don'ts that ended up working and didn't end up working. And this idea of treasure hunters, right, developing the technologies, having the investors going into the water, going into, say, getting these sunken vessels or resources under the sea. And that was happening and happening as fast as what it could happen, but there was no enforceability. There was no way to monitor. I mean, if you were in warm waters in the Caribbean, not deep, that was very easy to extract. Now, when you develop the technology to go all the way down deep into the ocean where it's cold and there's pressure, there's a lot of investment. And so a lot of investment in that technology, because most states didn't have that technology, the investors were expecting a return, which is normal. And so there was one case, the famous Black Swan case that happened in the early 2000s. A treasure salver company went and found a vessel that had $500 million of worth of silver and other precious metals, which I say precious metals very specifically. And so finders, keepers, salvage law, they filed in the proper documentation in the U.S. We're able to bring the cargo onto planes, put them on seat belts, and got them to Tampa. Very happy, all smiles, National Geographic. However, at that time, then we've got the development of technology, Facebook. People can see what they could not see decades ago, and Spain saw that this was one of their vessels and said, hey, that's our vessel. And before, when a vessel would fall into the sea, it was like gone. You don't think it's going to be mine. My helium balloon just left and it's mine. It's just gone. But as the technologies developed, because of private investors, then these objects were found, and then there came claims, despite all of the treasure salvage vessels, for example, around Florida, the Florida coast. Now came a claim by Spain that said, we never abandoned our claim over ownership of the vessel and its cargo, and we have jurisdiction over the vessel. So that is ours and everything in it. But under the maritime law, under U.S. law, the idea would be that the salvers would be able to keep the claim. Then again, with technology, Peru, as a country of origin, said, well, that material came from our country, so it should be returned to our country because the age of colonization is over, which also was very coincidental in timing with the 1967 treaty, which does not allow for appropriation of territories because we were creating the documentation for decolonization at that period, right within the UN. And those space and decolonization actually report to the same UN same committee at the General Assembly. Okay, so which is very interesting. But in any case, at the end of the day, the U.S. didn't could not decide on title because that's a very tricky diplomatic issue, particularly because of the 2001 UNESCO convention that came in. So what did it do? It defaulted to a 1700 something law agreement between Spain and the US, which would force either country to give deference to the other in terms of jurisdictional matters. So the US gave deference to Spanish jurisdiction. So that means that the case would have to be decided in Spanish courts. Spain's Royal Armada flew their planes to Tampa, brought the gold back, and put them in the same bank vault that they would have been in had they arrived 200 or 300 years before. Now, the question of title was never discovered. However, what about the treasure salvers who invested in this, all of their investors? So they ended up with no gold and silver. They ended up having to pay for legal fees, and it was a big mess. And so the thing is, even though we can go and try to get as much as we can, the laws can then develop, which at another point can really take away that investment. So there has to be a lot of thinking and analysis and caution before diving into similar situations outside of space.
Thank you very much for that. I want to give Tony a chance to hop in with any final thoughts on that conversation. Okay. Anyone have any final thoughts, questions, comments, any cool little bits you wanted to put out there before we wrap up?
Point, following on what Marlene said. So this is basically goes back to my point of, carefully craft contracts, do your due diligence, because this is an ecosystem where you can't just go to any lawyer and say, like, redline a contract for me. You have to understand so much nuance, and there's so much context here in a very nascent, like, commercial space industry that you really need to make sure, even from an investment perspective, right? There's so much going on. It's not just about the numbers and the contracts. There's all of this background, and it's always advisable to do due diligence from every angle and every aspect.
Well, thank you all very, very much. That was an absolutely fantastic conversation. I knew we were in line for a good one. Thank you all so much for sharing your expertise, your background on all these different fascinating topics. I hope here people in the audience found it insightful. I know we're already running a little bit late, so unless there are any burning questions from the audience.
Just real quick, last week, Trump executive order deep sea mining. Looks like we may be pushing that UN close law a little further out from enforcement. So, yeah, with respect to space and sea, and see how it goes.
It's also interesting that you mentioned that because it's one state. So how much does that apply? That one state may use the principle, say, well, this is our international law. Once we have jurisdiction somewhere, international law does follow outside first, and a state has jurisdiction over the object, like the module that they're working on, over their individuals. And so these nuances and how does this apply, this is very important. So it's really has to be a comprehensive understanding of the law, past, present, and the trajectory into the future.
Which is not, in situ materials and construction are not susceptible to registration, right? They're not launched.
Yeah, I mean, but the registration is also very complex right now under that UN treaty, and then multiple registrations because you have multiple parties undertaking a project. So it does get very complex. I wouldn't want anyone to leave the room and think, okay, if I do A, B, and C, there's my solution. There's a lot to think about, and it's really good to speak with people who can see different aspects of the project that sometimes have nothing to do with it. Yeah.
100 years, we'll probably have 4 registrable
Yeah.
facilities that are launched, right? And then you can build a dome around it. Is that what?
Yeah. Final thought to Michael.
Well, one of the things that I find on your point that I find gives me great comfort is that unlike the deep sea bed, there is no life on the moon, and so there's no ecosystem to destroy. And I think that should so mining the deep sea bed is quite a different thing, I think, than going to the moon.
All right. Thank you all again so much for joining us and sharing your expertise. Hopefully those in the audience with questions can find these folks afterwards. Thank you.